I guess we're going to go ahead and get started. And here's a panel now. We're going to be talking about the Privileges or Immunities Clause. And I'm just going to give a brief introduction based on agreement between me and the panelists, and then they're going to go right ahead. So this is obviously a very exciting time in terms of thinking about politics and the Constitution. And I think it's safe to say that there's nothing that's been more sort of politicized than the debate over the meaning of the Privileges or Immunities Clause since the Reconstruction Congress enacted it. Actually, the idea of privileges or immunities of citizenship was a political issue even before the Reconstruction. Abolitionists such as John Bingham made the argument that slaves were citizens and free, made arguments based on the Privileges and Immunities Clause that slavery violated that, and advocated that in favor of the rights of citizenship. Arguably, the Privileges or Immunities Clause was intended to be the principal source of rights under the 14th Amendment, but as you all know, the court interpreted it narrowly in the slaughterhouse cases, and few lawsuits have been brought since the beginning of the 20th century asserting rights under the Privileges or Immunities Clause. So we are going to talk today about the meaning of the Privileges or Immunities Clause, what type of rights there might be under the Privileges or Immunities Clause, since it's been very little, there's not very much case law, and I think we feel like there's a pretty good opportunity here for an expansion of rights under the Privileges or Immunities Clause. But what we're not going to talk about is the incorporation debate. We are not going to talk about the question of whether the Privileges or Immunities Clause was intended to incorporate the Bill of Rights, which has been the most controversial issue in the history of the Privileges or Immunities Clause and its treatment by the courts and by in the political debates. That is because, although in the early 20th century there was a general consensus that the Bill of Rights had not been incorporated based on bad history, the Dunning view of history, kind of negative carpetbagger view of Reconstruction, that since the early 1980s, due in large part to work of historians like Eric Foner and of legal historians, chief among them Michael Kent Curtis, that we all agree that the consensus among scholars is that the 14th Amendment did incorporate the Bill of Rights. Doug's going to talk a little bit about how this incorporation issue is going to come up very soon in front of the Supreme Court on the Second Amendment. And, but we're not going to, that's not going to be the focus of this panel because we all agree that that issue has been pretty much decided. So with that, Doug Kendall.
Thanks, Rebecca, and thanks again to all the folks at ACS who've done so much work to pull this together. My organization, Constitutional Accountability Center, is co-sponsoring this conference, and our main contribution is a report that should be out on the desk called The Gem of the Constitution, the Text and History of the Privileges or Immunities Clause of the 14th Amendment. And I want to just recognize David Gans from Constitutional Accountability Center, who's in the audience today, who served as the lead author of the report. I feel like Eric Foner's question last night to end the event at the National Constitution Center, brilliantly asked, then painfully unanswered, hangs over this entire conference. What are we to make of law when it departs so starkly from history? And nowhere is this cognitive dissonance between the Constitution's text and history and modern Supreme Court case law quite as great as in the area of the text and history of the Privileges or Immunities Clause and the protection of fundamental constitutional rights. As Rebecca just summarized, there has emerged in the last 20 years a remarkable scholarly consensus that the Privileges or Immunities Clause was supposed to be the centerpiece of the 14th Amendment and the vehicle by which we protect substantive constitutional rights and liberties. This consensus is new and incredibly important. For more than a century, this text in history was buried by Jim Crow historians who sought to limit the reach of the 14th Amendment and demonize its framers. We are privileged to have with us, as Rebecca noted, constitutional historians including Eric Foner, Michael Kent Curtis, and Dean Ains, whose work has formed much of the basis for this new consensus. And correspondingly, there's now broad agreement that the Supreme Court erred badly in the 1873 slaughterhouse cases, which effectively, and subsequent cases, which effectively wrote or erased the Privileges or Immunities Clause from the Constitution. Most fundamentally, the Slaughterhouse Court erred by viewing the 14th Amendment from a states' rights perspective, stating at one point that a broad reading of the Privileges or Immunities Clause would fetter and degrade the states. Horrors. As Akhil Amar has summarized, virtually no serious modern scholar, left, right, or center, believes slaughterhouse is a plausible reading of the 14th Amendment. So there is, on this one hand, this remarkable scholarly consensus about what the Privileges or Immunities Clause was supposed to mean. And there is then, on the other hand, the law and the political debate over the law. And as we all know, the law has been perverted by the slaughterhouse opinions, with the Privileges or Immunities Clause effectively read out of the document. The Supreme Court turned to the Due Process Clause as both a vehicle for applying and incorporating substantive protections of the Bill of Rights against state action and for protecting unenumerated fundamental rights and liberties. The result is a doctrine known as substantive due process. For a number of reasons that don't need to be rehearsed here, substantive due process is a less than perfect constitutional actor for this role. This has led to a constitutional equivalent of a food fight over the last 30 years. Conservatives have attacked substantive due process as Exhibit A in their argument that liberals want judges who make up constitutional law as they go along. Liberals view this attack on substantive due process as Exhibit A in their assertion that conservatives want to roll back protections even for the fundamental liberties that are protected by the Bill of Rights. And the whole debate, frankly, makes you want to scream, because even in the age of textualism, this entire discussion is devoid of any discussion of the text and history that is most relevant here. So the important questions for this panel are, one, can this conversation be changed? And two, what happens if it does? And I'll just speculate on both those questions quickly. There are two big reasons why I think a possibility this conversation is changing. The first is a 1999 Supreme Court case called Saints versus Roe. In Saints, the Supreme Court, by a vote of 7-2, invalidated a California welfare reform measure as a violation of the Privileges or Immunities Clause of the 14th Amendment. This is the first time in modern Supreme Court history that the court has treated the clause as anything but a dead letter. And it was written by Justice Stevens, joined by Justice Kennedy and Scalia. Justice Thomas is the only member of the court who dissented, is the current member of the court who dissented, and he indicated he'd be willing to fundamentally rethink the Privileges or Immunities Clause. So there's some sense that there's support across the political spectrum for some measure of reconsideration of the clause. And then, as Rebecca mentioned, I think the Supreme Court's ruling last term in Heller sets up a really interesting test for the Supreme Court's, particularly the conservatives on the court, who purport to follow text and history. The next question is whether the Privileges or Immunities Clause is incorporated against state action. The only textual way you can plausibly do this is through the Privileges or Immunities Clause. And already Alan Gura, the Supreme Court advocate for Heller, and a number of preeminent constitutional historians, including Dean Ains and Professor Curtis, have advocated incorporation through the Privileges or Immunities Clause. So this test is coming in the next few years about what this clause means. Now, that would obviously open up a number of enormously important and interesting questions about what constitutes the privileges or immunities. And we speak to these issues in the report, and and I think that's what most of the rest of this panel will be about. I think in particular the concept of citizenship, which Goodwin I think will discuss in detail, is a fascinating one that we need to consider in a lot more detail. But I want to pause here for a second and consider the importance of a ruling that brings back, that gives us back a privileges or immunities clause, even if, regardless of what direction the Supreme Court goes in its jurisprudence. This is a passage from Barack Obama's book, The Audacity of Hope. For all our disagreements, we would be hard-pressed to find a conservative or a liberal in America today, whether Republican or Democrat, academic or layman, who does not subscribe to the basic set of individual liberties identified by our founders and enshrined in our Constitution and our common law. The right to speak our minds, the right to worship how and if we wish, the right to peacefully assemble, to petition our government, to own and buy and sell property, and not have it taken without just compensation, the right to be free from unreasonable searches and seizures, the right not to be detained by the state, and the right to make our own determinations with minimal restrictions regarding family life and the way we raise our children. We consider these rights to be universal, a codification of liberty's meaning, constraining all levels of government and applicable to all people within the boundaries of our political community. Moreover, we recognize that the very idea of these universal rights presupposes the equal worth of every individual. In that sense, wherever we lie in the political spectrum, we all subscribe to the founders' teaching. And I think President-elect, it's a nice thing to say, Obama, is right. Americans believe in a basic set of equal and inalienable rights. This is little more than a restatement of the central passage of the Declaration, a passage that defines the idea of America and our national creed. The problem is that the specific provision that was intended to write the ideas of the Declaration into the Constitution has been written out of our framing document, our founding document. All Americans should cheer and push for a ruling that finally honors some of our Constitution's most important text and history. And I think if we start talking in common constitutional language, we may just find that President Obama is right and that we agree more than we think we do about our equal and inalienable rights.
Thanks. Randy Barnett.
Hi. Well, it's, again, a great pleasure to be here. It's a wonderful program, a very important topic. And I am part of the new consensus about the meaning of the Privileges or Immunities Clause, that it includes the protection of the Bill of Rights, and there's no need for a substantive due process clause to provide that protection. And as Rebecca said, that's not really what the panel is about. We're not trying to prove that point. My contribution is to begin focusing on how the term privileges or immunities includes more than the protection of the rights that are enumerated in the Bill of Rights, and in particular includes the protection of what was called in the 39th Congress natural rights. Now, to do an original public, I'm going to resist the temptation to turn my time over to a discussion of what originalism is and how it should be done. But if you take an original public meaning approach to the text of the Constitution and you're looking for the semantic meaning of the words on the page in context at the time they were enacted, you would look at all kinds of evidence to show what word usage was, how the words were used at the time. And you would have to do a threshold decision, make a threshold judgment based on the evidence as to whether words are used in their common usage or whether they're terms of art. So, for example, the word commerce in the Commerce Clause, I think the evidence is pretty clear, was a term in ordinary usage. It was more distinctive than the term is today. It excluded agriculture and manufacturing, for example. It was widely used in that sense. It was meant to be used that way when it was put into the context of the Commerce Clause. The term privileges or immunities, however, looks a lot more like a term of art. A term that the general public would take a look at and wouldn't be exactly sure what it means, but would basically say, well, no, that's something a lawyer might need to tell us what that means. You know, to look to a lawyer, I wonder what a lawyer would say that would mean, or people who knew. And in fact, I think it is a term of art, and the evidence of its meaning is available to us. It's not hidden, it's not obscure. So I'm going to go over some of that evidence to the extent I can in the time I have. And there's a lot of it, but there isn't like so much of it. Richard Ames in his paper gives a lot more of the evidence about the origins of the phrase privileges or immunities. I'm simply going to focus on two pieces of evidence about that. One is Blackstone's use of the term, which Michael references in No State Shall Abridge, where Blackstone refers to those private immunities which will appear to be indeed no other than either the residuum of natural liberty, which is not required by the laws of society to be sacrificed to public convenience, or else those civil privileges which society hath engaged to provide in lieu of the natural liberties so given up by individuals. And these may be reduced to three principal or primary articles: the right of personal security, the right of personal liberty, and the right of private property. And this description of both the immunities, private immunities of citizens, and the civil privileges of citizenship is repeated over and over again in different variations without quoting Blackstone, just doing something very similar. The most famous American statement of privileges or immunities is the statement by Justice Bushrod Washington in the case of Corfield versus Coryell, which most of you have heard about. You might think of this circuit court opinion as an obscure case. It was not obscure at the time of the framing of the 14th Amendment. In fact, it was repeatedly cited by members of Congress in discussing what privileges or immunities was and quoted in its entirety. The congressional record is replete with one quote after another. One of the same quote is reproduced in various places, and one assumes they read these out loud and didn't insert them in the record later on. Maybe they had the practice of inserting them in the record, but there it is, the same quote. I'm just going to read you the first. It's a long quote. I'm not going to read you the whole thing. I'm just going to read you the first part to give you some flavor of how privileges or immunities relates to natural rights. The inquiry is, what are the privileges and immunities of citizens in the several states? Corfield versus Coryell is about the meaning of privileges and immunities in Article 4. We feel no hesitation in confining these expressions to those privileges and immunities which are in their nature fundamental, which belong of right to the citizens of all free governments, and which have at all times been enjoyed by the citizens of the several states which comprise the Union from the time of their becoming free, independent, and sovereign. What these fundamental principles are, it would perhaps be more tedious than difficult to enumerate. They may, however, all be comprehended under the following heads: protection by the government, the enjoyment of life and liberty, the right to acquire, possess property of every kind, and to pursue and obtain happiness and safety, subject nevertheless to such restraints as the government may justly prescribe for the general good of the whole. Then it goes on with a lot more specifics, including some that provide some difficulties, like including the right of franchise among the privileges or immunities of citizens, something that may have been rejected later on. But there you have it. Now, that's one of the things that a public meaning analysis would look to. Some of the types of evidence, the origins, the intellectual origins, in this case, of a term of art. Obviously, another category of evidence we'd look to are statements made about the meaning of this clause while it was pending, while it was being discussed. And, in fact, we have to understand, and everybody in this room does understand, that it's almost a truism that the 14th Amendment was enacted in order to ensure that Congress had the power to enact the Civil Rights Act of 1866 and the Freedmen's Bureau Act of 1866, as well as other civil rights bills that were under consideration then and in the future. So it's useful then to be, the next piece of evidence one would look at is what were the privileges or immunities identified in the Civil Rights Act of 1866 and the Freedmen's Bureau Act of 1866. And so let me just read you those. The Civil Rights Act of 1866, such citizens of every race and color, without regard to any previous condition of slavery, shall have the same right in every state and territory of the United States to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, lease, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property, as is enjoyed by white citizens. Now, this is, of course, an anti-discrimination clause, not the same wording that was adopted in the 14th Amendment, but we're talking about the substance of the privileges or immunities of citizens, not whether they're being protected from discrimination or absolutely. And finally, since I'm seeing my time is nearing an end here, the Freedmen's Bureau Act of 1866, that it be it enacted that in every state or district in which the ordinary course of judicial proceedings has been interrupted by the rebellion, the right to make and enforce contracts, to sue, be parties, and give evidence to inherit, purchase, sell, hold, convey real and personal property, to have full and equal benefit of all laws and proceedings concerning personal liberty, personal security, and the acquisition, enjoyment, and disposition of estate, real and personal, including the constitutional right to bear arms, shall be secured to and enjoyed by all citizens of such state. If you've noticed a certain repetitive quality of this evidence, I think you're in good company. This evidence is relatively repetitive. First thing I will note about this, most of these rights, except for the right to keep and bear arms, are not contained in the Bill of Rights. These are rights deemed to be fundamental that are going to be protected, in this case by statute, and later by a constitutional amendment which will both ensure the constitutionality of that statute and ensure that those statutes will not be repealed by a future Congress once the southern states get readmitted to Congress, that refer to unenumerated rights that are not included in the Bill of Rights. It's quite clear. And one can, if one had more than the remaining 1 minute I have, begin to generalize about what the nature of these rights are and what they have in common. I have, in my work, summarized them as liberty rights. These are the rights that people have to do or refrain from doing that which they will with what is theirs, which is what is properly theirs, subject to the reasonable regulation of the government that exists under the laws to protect the rights of others. It's almost a truism, and in fact, contrary to Justice Holmes, you will even see invocations of Mr. Herbert Spencer's social statics in the 39th Congress invoking this law of equal freedom, which is what I've just basically paraphrased, as essentially the background liberties that everybody has. Okay, well, what I'm not going to then read to you is a few of similar statements by proponents of both the Civil Rights Act and then also the proponents of overriding President Johnson's veto of the Civil Rights Act on the grounds that these are perfectly supportable privileges or immunities of citizens, and also similar statements made by people who advocated and were explaining what the Privileges or Immunities Clause meant in the 14th Amendment. So even though, and this will be my concluding remark, I meant to say this in the opening, but I didn't say it, there is a consensus that the Bill of Rights is among the privileges or immunities, an academic scholarly consensus that the Bill of Rights is among the privileges or immunities protected by the 14th Amendment Privilege or Immunities Clause. There is no academic consensus that natural rights are also among the privileges or immunities of citizenship. However, I would say there is no academic dissensus either. There just has been a lack of academic focus on this question, and I think that when focus turns to the Privileges and Immunities Clause, as it may in the wake of the Heller case, the evidence will be pretty clear that it clearly refers to unenumerated rights of a fundamental nature that are sometimes referred to as natural rights.
Thanks, Randy. Richard Ains.
Thank you, and it's nice to be able to build on Doug and Randy's comments. Judge Bork famously said that the Privileges and Immunities Clause is an ink blot. We can't figure it out. And I want to suggest that he didn't try very hard. I think I sat down with a little book called Sources of Our Liberties that the ABA published back in the 60s, and about a half hour came up with 10 or 12 different examples where we use, founding documents use either immunities or privileges or both. And perhaps the two worthy of mention is way back in 1606, not quite as far back as Blackstone, but the first Virginia Charter says that the colonists will have and enjoy all liberties, franchises, and immunities as if they were been born or lived in England. By the third charter, which is 1612, the word privileges is added to that list. So we have privileges and immunities being used in common documents, in legal documents, almost 250 years before they're proposed to be inserted in the 14th Amendment. Michael Kent Curtis has analyzed a number of these documents and said basically they seem to be using rights, liberties, privileges, and immunities interchangeably, and I think that's true. William Rich of Washburn has a fine article out in which he documents what I think we've all encountered, that these same terms are used in corporate charters in the 19th century, they're used in contracts in the 19th century. This is not some big mystery. This is not something it takes a long time to figure out what the terms mean. It may be challenging to figure out what rights are, but we also see these in state constitutions. Now, one of the people that academics that really turned the world on its head, I think, was Charles Fairman with his 1949 article that prior to that time, everybody thought the slaughterhouse dicta was wrong. Some celebrated it for being wrong and said it's great. Some objected to it. But Fairman tried to put a spin on this that it was actually very consistent with what the record showed. Nevertheless, in a 1950 speech at Boston, Fairman said it was plain that the Privileges and Immunities Clause was the vehicle through which the 14th Amendment framers and ratifiers wanted to provide what he called substantial rights. And one of Fairman's friends and advocates of this position later in time was Justice Robert Jackson. But in 1941, in Edwards versus California, Jackson wrote that the purpose of the Privileges and Immunities was to give vitality to the Citizenship Clause. So here we have two people that have some reluctance about this, and yet they're willing to admit that it was Privileges and Immunities that's to be the leader here. And they're trying to figure out, well, what's the scope? Is this broad or narrow? And I suggest a good indication of that, Justice Strong writes in Straughter versus West Virginia, the 14th Amendment makes no attempt to enumerate the rights. Notice he's calling these rights, not privileged immunities. It is designed to protect. It speaks in general terms, and those terms are as comprehensive as is possible. So we're dealing with a fairly broad position, and I'm going to turn in just a minute to try to suggest how that could apply to some specific instances today. But I think one thing to be careful of is that these clauses are largely, although not entirely, designed to provide duplicate protections. And that's kind of contrary to some of the rules of construction we use. But the reason for that, you heard from the prior panels, everything they thought was true, everything they tried, didn't work. The courts didn't enforce it, the people didn't accept it, so they're trying to build multiple protections in here. And one example of that is in 1862, 14th Amendment author John Bingham, when they're debating the abolition of slavery in the District of Columbia, says that one of the chief privileges of American citizenship is the right to due process of law. So you see there's the duplication here. Bradley, in his dissent in Slaughterhouse, says one of the chief privileges is the right to equal protection. So we're not parsing out four different categories here. I think more so than his colleague Fairman, Justice Jackson had a correct approach in Edwards when he says, this is a difficult thing for us, the court, to do, and he cites a past dissent. But he says the difficulty doesn't relieve us from the burden of doing the task. And it seems to me, whether you think this is a simple task, like some of us do, particularly on the Bill of Rights side, or whether you think it's a more difficult task on some of the other protections, the fact that it's difficult, as Jackson says, doesn't relieve us or the courts from trying to find that solution. And Jackson points out, I think to his credit, that there's other general provisions in the Constitution, just as general as privileges and immunities, and it hasn't stopped the court from giving content to those. And I want to just try to run through briefly, you'll see some very briefly, four concepts here. Establishment Clause, Second Amendment, habeas corpus, and what I call the right of family life. There's some concern, and I confess it's a concern that I share, that if we go to privileges and immunities, will this present a pretext for the court backing up on its Establishment Clause jurisprudence? And all I can suggest here is not if they're faithful to the record, not if they're honest. I think it's maybe not widely known, but it's certainly well established historically that the Southern churches, just made the mistake I don't like, the white Southern elite slaveholders who controlled the churches in the South seceded from the Northern churches almost a decade before the war came. And why did they secede? Because they didn't like criticism of slavery. They wanted to establish churches in which slavery was viewed as destiny and God's will. And that's why you have so many regulations about preachers, both before and after the 13th Amendment, because there's an establishment issue there that I think the 14th Amendment privileges and immunities would prevent. And there's a couple of good articles on this. I don't think a lot of people have done work on it, but we get to this congressional election of 1866, which is considered a referendum on the 14th Amendment, and the author, John Bingham's out on the campaign trail. He talks about how important free exercise is and how it will be protected once the 14th Amendment is adopted. And then he adds, but we do not ally, A-L-L-Y, we do not ally church and state. So, I mean, to me, it's very clear that they're looking at that. Second Amendment, I'm not going to say anything except I think incorporation applies there. I want to mention habeas corpus because in a lot of the literature and also some of the court's recent cases, they seem to look to Article 1, Section 9, the anti-suspension clause, as the source of the constitutional value for habeas corpus. In Corfield, which was just discussed, Justice Washington specifically says habeas corpus is one of the Article 4 rights that's fundamental. In the slaughterhouse cases, both in Justice Miller's majority opinion and in Bradley's dissenting opinion, they both say the writ of habeas corpus is protected by the 14th Amendment privileges and immunities clause. It seems to me that's a much more direct, a much more strong, and a more protective constitutional basis for the amendment than what we would normally have. And I want to just illustrate one last point of where I think we see this in other rights. And I think both in property, in family law, and in constitutional law, a lot of the leading case books use a case called Moore versus City of East Cleveland, which the plurality decides is a substantive due process case. Now, I guess fair disclosure should say that when I was a very young law student, I worked on this case. But if you think about that, we tried to use the Ninth Amendment and say there's a right of family life. We tried to use First Amendment right of association, with the family being the most basic unit of association. We thought it was really an equal protection case. The court, in its wisdom, decided it was a substantive due process case. But whether you look on family life broadly or you break it down into right to marry, right to control your children's education, it seems to me that the prior panel that talked about all the harms to family under slavery, and that spills over to 14th Amendment, would suggest that those type of rights are also better protected and more logically protected under the 14th Amendment, and they connect back to this idea of equal citizenship and that citizens have that citizens have rights. And I just want to say, to conclude, mention was made of the Saines versus Roe case. We haven't really seen much activity there, and I tried to check this out because, you know, your gut reaction is that the courts aren't doing their job, but what I got back from an assistant was that there were only about, well, it's cited maybe about 100 times. Most of the times there's no privileges immunities issue in those cases, and I think there were 3 cases, a couple of cases they held that it really wasn't a travel case, and in one case they held that they were bound by the dicta of Slaughterhouse, even though they didn't recognize that it was dicta. So I think one of the tasks is to do things like Doug's organization is doing and others, and that is we have to get the message out to lawyers who are doing litigation to bring these type of cases, to use the privileges immunities, to see if we can't realign the jurisprudence, and I think we end up in a far better position if we're able to do that. Thank you.
Thanks so much, Richard. And now we'll have Godwin Liu.
Thank you so much. Delighted to be here and very grateful to Penn Law School for the hospitality, and I'm very pleased that ACS has been able to put together such a remarkable group of scholars with Doug's help as well to examine this really timely topic. My co-panelists have spoken very eloquently about the Privileges or Immunities Clause as a textual basis for many of the individual liberties that we've recognized under substantive due process or various incorporation doctrines. I want to suggest that the privileges or immunities of citizens of the United States, that text, encompasses not only concepts of liberty, but also the other fundamental principle of the 14th Amendment, and that is the guarantee of equality. So since Brown, we have largely housed are equality jurisprudence under the textual guarantee of equal protection of the laws. But well before the 14th Amendment mentions equal protection, it leads with the concept of citizenship. And my point here is that inherent to citizenship is a guarantee of equality. Some of you know or may remember that Charles Black argued in his little book, Structure and Relationship in Constitutional Law 40 years ago, that even if the second sentence of the 14th Amendment had simply been omitted, the citizenship guarantee in the first sentence would have provided really ample basis, perhaps even a better basis, as I'll argue in a second, for a robust jurisprudence of equality. And as a historical matter, I guess I would say that this was pretty well understood by the framers because, as Randy mentioned, the framers wrote Section 1 of the 14th Amendment largely to secure Congress's power to enact the Civil Rights Act of 1866. And here I'm going to put a slightly different spin on the Civil Rights Act of 1866 than the one Randy mentioned, which is that the 1866 Act drew an unambiguous connection, I think, between citizenship and equality when it said, all persons born in the United States are hereby declared to be citizens, and then the very next phrase is that, and such citizens of every race and color shall have the same right to make enforced contracts, to sue, be parties, give evidence, sell and hold property, and to full and equal benefit of all laws and proceedings as is enjoyed by white citizens. So to me, that states an equality principle. It could also state a liberty principle, but it is with respect to these rights, as is enjoyed by white citizens, they shall be enjoyed by all citizens. And so, in other words, the guarantee of a single national citizenship was understood to entail a guarantee of equality among its members. So you hear Justice Bradley saying in dissent in the Slaughterhouse case, quote, if a man be denied full equality before the law, he is denied one of the essential rights of citizenship as a citizen of the United States. And similarly, Justice Harlan, dissenting in the civil rights cases, says citizenship in this country necessarily imports at least equality of civil rights among citizens of every race in the same state. So now, what is the legal significance of understanding equality as a citizenship right as opposed to an equal protection right? Well, the phrase equal protection of the laws obviously is open to a variety of readings, but as Owen Fiss explained 3 decades ago, the courts have largely read it to stand for an anti-discrimination principle. And the anti-discrimination principle, as Fiss argues, is centrally concerned with the problem of classification. In particular, whether the fit between classificatory means and substantive ends is, in some sense, sufficient. Okay, that's the equal protection game, as it were. This, he says, yields a very highly individualized conception of the equality right, namely that any person who is burdened by a statute or excluded from a benefit can complain of a wrong. The social meaning of a particular classification, including its impact on social groups, is either a secondary concern or not a concern at all. Right? And then further, the anti-discrimination principle is one that contemplates state action, because there must be an official act of classification before the discrimination inquiry is triggered. Okay. Now contrast this rather thin and almost mechanical notion of equality with the more socially situated inquiry into what it means to be a full and equal member of one's society. The right to equal citizenship is, to quote Ken Karst, who I think said it best, the right to be treated by the organized society as a respected, responsible, and participating member. Now, if that were the animating principle of our equality jurisprudence, we would end up, I think, in some very different places. And let me give 3 quick practical examples. I think the first and most obvious is affirmative action. The problem of affirmative action, I think, has failed to produce much in the way of intellectually satisfying doctrine, because if you start from a principle of equality that lodges a heavy presumption against classification by race, it's unavoidable that the justification for affirmative action is going to be very uneasy at best. But if you start from a principle of equality that asks whether affirmative action is consistent with the full and equal citizenship of individuals in our society, it's more difficult to make out the injury. One could say that the Michigan affirmative action policy lowered Barbara Gruder's chances of admission, but did it relegate her to second-class citizenship? Surely that's not the way she framed her case. I think the same thing could be said about the parents-involved school desegregation cases. Those race-conscious policies are very difficult to sustain under the anti-discrimination principle because, as Chief Justice Roberts argued, the classifications transparently suffer from over and under inclusivity with respect to the goal of diversity. But can it be said that placing white students in racially integrated schools against their choosing undermines their status as full and equal citizens in our polity? I think it's hard to think of a policy that affirms the full and equal citizenship of the members of society more powerfully than racial integration of public schools. Second example is state action. So note that like Section 1 of the 13th Amendment, and this is Neil's question about reading these two things together, the parallel is not accidental, I think. The citizenship guarantee is stated affirmatively in the first sentence of the 14th Amendment, unlike the privileges or immunities or the equal protection clauses, which are directed at the states. This observation is very central to Justice Harlan's dissent in the civil rights cases, where his primary argument for the constitutionality of the Civil Rights Act of 1875 was not that it was legislation to enforce the equal protection or even the privileges or immunities clause. It was a statute to enforce the citizenship clause, a clause, he said, quote, of a distinctly affirmative character that Congress may enforce directly without a state action predicate. And surely this theory resonates with our own cultural understanding of, say, the Civil Rights Act of 1964. It's a statute to enforce the constitutional guarantee of equal citizenship. And finally, the equal citizenship principle has a third implication for equality doctrine, and that is its selectivity with respect to the types of inequality that trigger constitutional concern. So some of you will remember a pioneering article in 1969 by Frank Michelman in which he cast doubt on wealth discrimination as a basis for equal protection claims. Michelman's point, I think, was that wealth discrimination is inherent to a market economy and is thus, like the general anti-discrimination principle, too encompassing and too logically unbounded to ground an actionable legal principle. Archibald Cox once said, "The idea of equality, once loosed, is not easily cabined." Okay? If we accept this, I think we might focus our equality jurisprudence in a couple ways. First, if our concern is equal citizenship, then not all degrees of inequality are constitutionally problematic. Michelman's insight was that some inequalities, and he would call them deprivations, go to the dignity, regard, and participation of persons as free and equal members of society, and some inequalities do not. Take school funding, for example, and I'll finish really quickly. We might worry that the median district, school district in California, is funded at a lower level than the public schools of Beverly Hills. But surely we ought to worry more about the schools that are funded at levels far lower than the median district, right? And so equal citizenship, I think, enables us to prioritize our concerns about inequality in this way. Second, and very lastly, the idea of equal citizenship, especially, I think, its latent emphasis on political participation, enables us to answer Michelman's famous question, why education and not golf, right? When it comes to inequality, some substantive domains matter more than others. That was the point of the fundamental interest strand of equal protection analysis, which is a doctrine, in my view, that is more readily and firmly anchored in the equal citizenship principle. So an equality jurisprudence that can't distinguish between education and golf is a jurisprudence that is missing something very important, and one I think that's ripe for incremental and, I would say, achievable judicial reform.
Thanks so much, Goodwin. So you guys have given us a lot of food for thought. There's Barry has a question right back there.
I enjoyed this a lot, and I learned a lot, but I guess I'm left with a question, which is that I would have liked some more tangibility for most of you. Now, we were getting it at the very end from Goodwin, but I'm going to actually be a little skeptical, too, but I'd like to know what it means to switch over to the Privileges and Immunities Clause from the Due Process Clause. And mind you, as a con law teacher, it would sure make not having to explain substantive due process anymore. It would be no problem in my life any longer, and I'd welcome that. But in tangible terms, what do we gain? And in part, I worry about what we lose. I mean, there's been some conversation about that, you know, the point that there's citizens in the Privileges and Immunities Clause instead of persons, the concern about the Establishment Clause. And so, you know, before progressives jump on the bandwagon, I'd want to know what the stakes are of getting on that bandwagon. I'm also not sure that we get all the gains that I didn't understand the affirmative action argument, for example. I mean, it still would remain for somebody to challenge an affirmative action plan under the Equal Protection Clause, so the Equal Protection Clause doesn't go away. So I kind of know what we get from this, what are the risks from losing it in really, really tangible terms. And I'll just mention, I thought to say this on the last panel, that sometimes I wonder more generally what we get out of clause shifting, what it does for us. I mean, I assume there's a certain logic to where we got in the doctrine that doesn't always relate to the clause, but we got there by sort of thinking through, you know, somebody's asserting a right, but then the state might have an interest, so we have to balance it. And I don't expect all that's going to go away just because we shifted clauses.
Let's take a couple more questions, and then I'll have you answer. I was thinking we'll try to do 3 at a time. So, Richard?
Richard Primus from the University of Michigan. My question is sympathetic to the spirit of barriers, right? It seems to me that it's hard to imagine a court that would do great and wonderful things under the Privileges and Immunities Clause that wouldn't do the same thing under the Due Process Clause. Or, to put the point a little bit hyperbolically, and if you took that away, who couldn't do it under the Duty of Tonnage Clause, right? That is to say, you use a clause, you use a different clause, and a jurisprudence develops, right? So what makes you think that if you only switched over to privileges and immunities, all the substantive law would change? It can't be, because you think that once they do that, they'll follow all the texts of the first several amendments. We don't agree what those mean. And the premise seems to be that judges aren't very good at following text. If they were, you wouldn't have the problem, right, in the first place. When is clause shifting useful? Sometimes clause shifting is useful because there's been court shifting, and a new court prefers not to overrule, right? This is why the clever move in the voting rights cases is to say we're not doing guarantee clause anymore. That was Colgrove, and we can't do that. We now want to do Baker, and it's a totally different thing. So we're going to give you a different clause, and we're going to litigate it under the Equal Protection Clause. But the reason it works is that the court is in a substantively different place. The court wants to recognize the claim now and didn't want to recognize it before. So are you saying that with the same set of judges, you produce new results under privileges and immunities that you don't under the existing set? And if not, then it's a very interesting exercise, but might not the effort be expended better elsewhere?
Okay, thanks. And Michael?
Yeah, 2 points. Michael Curtis from Wake Forest Law School. One, following up on that concern, if you read Frankfurter in Adamson, he talks about why incorporation is crazy under the Due Process Clause, and then he says, and I won't discuss the Privileges or Immunities Clause because of the mischievous purposes to which it could be put. So what's he worried about? He's worried about Randy's sugar plums dancing in his head, of Herbert Spencer's social statics coming back. But he doesn't view this as a positive thing. So that's one. Another thing, at least if you follow the jurisprudence, one interesting thing would be corporations probably wouldn't have privileges or immunities. Corporations, maybe being artificial persons, don't have natural rights. And they may not have these other rights. So, you might shift things in that way, which you might or might not like. Those of us who are unenthusiastic about bringing the corporations into all of these rights might find it better. A second point about the Civil Rights Act of '66. I used to think it was an anti-discrimination provision only. And that gave me a lot of trouble in understanding it in terms of, what people said about the 14th Amendment being the Civil Rights Act and so on, but it's not. It's not because of the phrase full and equal benefit of all laws and provisions for the security of persons and property. And that phrase, laws for the security of person and property, encompassed a lot of these traditional English rights, Bill of Rights rights, and so on. And the phrase is used all the time. And you show people, and this is something else, you see people saying things like, well, now that we've got the Civil Rights Act, we have free speech throughout the nation. Well, and these are people who knew that free speech didn't mean that the sort of equality of free speech that everybody got in South Carolina, which was no right to criticize slavery at all, or you'd see people who say other sort of rights. So I think it goes beyond equality. Those were my comments.
All right. Want to just go down the line?
Sure. Obviously, a tremendous amount on the table. I guess the first reason why you shift is that it's the right answer under the Constitution, and I think that's pretty clear. The second, and I think that's what the history and the consensus that we're talking about demonstrates. The second point I'd make is that I think, well, and it's a point that Charlie Black made in his book, New Birth of Freedom, where he talks about how judges are playing, or how our judges are interpreting substantive due process these days. And he referred to an actor who was playing Hamlet, and he said he was playing the king like he was waiting for somebody to play the ace. And the point being that judges right now feel like they're doing something illegitimate when they recognize a new right under the due process clause. And so therefore, you see all this hemming and hawing about this is something that we have to tread on with the most great and the greatest care. And so I think we have our conversation about fundamental rights and liberties in this country has largely run aground and isn't going anywhere. The third point I make in terms of what does this do, I do think, and what are the consequences of it, something that I think is quite important is that we don't lose the lessons that we've learned over the last 135 years in wrestling with the question of what are fundamental rights and liberties. I think the court has been wrestling under the wrong textual language, but I think that's essentially what they've been doing. And I think that history yields two pretty important lessons. One is what Richard has called these rights of family, rights of heart and home, we call them in our report, stemming from Meyer, the things that rooted in the tradition or the history of the treatment of slave families, has proven, and this is something that Justice Thomas cites affirmatively in his Troxel dissent, and something that Justice Roberts refers to affirmatively and supportively in his Senate testimony, that we seem to recognize, and that those things, those rights of heart and home, those family rights, seem to be relatively uncontroversial. That strain stemming from Meyer, not in all of its roots and branches, but that there is a core of relatively uncontroversial fundamental rights at this point. And the flip side of that, and I think it answers a little bit of Randy's issue, is that we did for 40 years try to wrestle with the boundary between economic liberties and the police power. And I think I think there's been a lot of renaissance around Justice Harlan's dissent in Lochner as being the stronger answer than Justice Holmes, and I think I agree with that, which is that the problem with Lochner is not that the framers of the 14th Amendment didn't care about economic liberties. It's just that there's always been a police power backdrop, and the problem is that the court in Lochner was remarkably inconsistent in the way it drew that line and stepped over that line. And so I think both those histories inform where the court would have to go under privileges or immunities, and then I think that there are, and this is, I mean, if you look at Justice Ginsburg's dissent in the Carhart opinion, I mean, she says this remarkable phrase that's something around, the right to reproductive choice is not rooted in some generalized notion of privacy, but rather in a woman's equal citizenship stature. And I think in that, and I think this is a point that Goodwin kind of alludes to and gets at, but this notion of citizenship, I think is in some sense, is a stronger notion and a way of informing the debate of fundamental rights and liberties that is worth pursuing.
Several questions have come up that are characteristic of law professors' discourse, which is, what do we get and what do we lose? How are the results going to be better, or how do we get to keep all the good results we like and get a few more good results, and how we're not going to get these bad results? And if you can sort of give me the answer to that, I'll know whether I'm for your method of interpretation or not. Now, I'm very familiar with this way of thinking. I'm a law professor myself, so I'm accustomed to it. But there is another way of thinking that many non-law professors have, and that is the idea that you look to the Constitution to provide guidance for which results are the right or constitutional ones and which results are the not constitutional ones. In other words, you don't read into the Constitution all the results you want and say, well, that's what the Constitution means, but you somehow look to the Constitution to get out of the Constitution information about what's permissible, what's impermissible. Now, I know all the objections to that, and having to do with either the indeterminacy or really more practically the underdeterminacy of the language of the Constitution. But I think that's no excuse for not finding whatever meaning the language does bear. And so therefore, what would you get? I'm going to resist the temptation to go down a list of results and say, well, you get these, you get this is in, this is out, this is in, this is out. And for one thing, I'm not even sure I know the answer to that. I do think, by the way, by and large, much of what currently exists is in, just to get that off the table. In fact, but here's a major benefit I think you'd get. And I think this is a real social benefit that cannot be put in terms of specific results. And Doug's already used the word. You get legitimacy. The court has, ever since Caroline Products, actually ever since Griswold, been in the business of protecting unenumerated liberties. I'm just going to focus on the liberties part here. I'm not denying, by the way, I just want to make it clear that there isn't an equality component of all three of the working parts after the Citizenship Clause, not just the Equal Protection Clause, which happens to mention equality. There's an equality component of the other two parts as well, but I'm just talking about liberty here. So the courts have been protecting unenumerated liberties fitfully since Griswold, since 1965. That's the way back when in the founding of, that's the third or fourth founding, 1965. But ever since they've been doing that, they've been hammered for it because they've been doing it in a way that is not easily justified. At least they don't easily justify it. This is like George Bush trying to justify a policy, right? You don't look to George Bush for a wonderful justification of his own policies, right? Well, maybe you shouldn't even look to the court for a wonderful justification of what it's doing in protecting liberty. In part, there's many, many good historical reasons why it got separated from the text of the Constitution. There's a benefit attached to being able to defend much of what the court is currently doing and more that it's not currently doing. On the grounds that this is true to the original public meaning of the Privileges and Immunities Clause and the Due Process Clause and the Equal Protection Clause and the Citizenship Clause as well. So there's a huge benefit to that. And I think it would allow courts to do much of what they're doing. I can think of very few things they're currently doing that it would not legitimate, and do more that they're not doing because they themselves, as Doug has alluded to, think what they're doing is kind of making it up and kind of reading their... So even though they won't publicly say that's what they're doing, and I submit that no nominee by President Obama will go into his Senate confirmation hearings to the Supreme Court and say, you know what, I get to update the Constitution according to either my conception or our settled conception of public morality or because of what works now and changing circumstances. No nominee will say that, I predict, safely. No nominee ever has, no nominee ever will. Law professors say it all the time. Every day in class they say it over and over again, but no nominee will say that. So this gets you, and there's a reason for that, and it has to do with the fact that judges like to say to the general public that you're going to do this or not do this because the Constitution says it. And it would be nice if there was a closer fit between what the judges say and what the Constitution says. There'd be benefits for everybody if that were true.
I want to try to make 3 quick points. One is trying to think about how do we get here? And I think we get here because, by here I mean the court's current status of jurisprudence. I think we get here because of the Dunning School of Reconstruction History. Basically, we don't take the 39th Congress seriously, or the ratifiers, in the same way we did a bunch of other people who did other amendments and who did the original Constitution. And so it goes to the legitimacy point that Randy's making, but it seems to me that these things are very hard to explain to a lot of people. Even constitutional law professors tend to say, I noticed in 2 recent case books, said that substantive due process is an oxymoron. I can tear that apart and argue it a little bit, but the point is, even among ourselves, some of these things aren't that clear. And then we think about, well, how did we get into due process? And the answer is, we got in the way lawyers get into lots of things. Once they're convinced privileges and immunities isn't going to work, they're going to try some other angle. It's like taking a little brook and putting a dam up. The water's going to try to run around. Well, maybe we've now run our course on due process, or certainly substantive due process, and privileges and immunities adds an ability to run around that. And I'm not, I guess I'm just thinking from a litigation standpoint. If one door is closed, you try to use another door. And I'm not blind, let's say, to the difficulties here. One thing that reminds me, during the Reagan administration, we had a Deputy Attorney General come and speak, as you all often do things. And in one of the discussions, we were talking about affirmative action, and he was explaining how that you can't identify the parties that were harmed, and you can't establish the proximate cause and all of these things. And I simply said to him, borrowing an idea I think Boris Picker at Yale had previously written about, well, we can identify everybody who went to segregated schools prior to Brown. This is long enough ago, there were many of those people living. I said, why don't we simply give them a cash payment to help make up for what was done there? And then suddenly all of this great legal analysis went away, and he informs me, well, we're really against that as a matter of policy. And I suppose we run the risk with the court that if we give them new opportunities, we'll find out what they're telling us now isn't their real reason, but like my Deputy Attorney General, they'll come back and give us a bad result for some other reason. But again, I think, we need to be pragmatic, but I know in cases that I argued as a lawyer, I always felt the weight of responsibility left my shoulders once I'd made the oral argument in the court. And the court has to assume some moral responsibility for what the outcome is. And whether we can trust the current system to do that or not, I don't know. But I think we went awry. Again, one reason that went awry in Reconstruction, we had some brave district judges, just like we did in Brown. But in Brown, they had the Brown court to back them up. And in Reconstruction, we didn't have a Supreme Court to back them up.
Since this is an interdisciplinary gathering, I want to try to, rescue our profession here from, the sort of answer about what do we get, what do we lose. It sounds so incredibly results-oriented. I hope that I'm not the only one in the room who tries at least to keep some faith that there is such a thing as the rule of law, and you try to get your students to take seriously the idea that the justices are actually trying to work through these things in intellectually honest ways, and that's why that matters. I mean, I think to me, both Doug and Randy hit it right on the head, so that's why I think it matters. I think Barry raises a very good question about the relationship between these clauses, equal protection or citizenship. I think, the point that Eric Foner made and what Richard sort of amplified in his initial comments really strikes me as correct, which is that it isn't so much that we should be sort of so clause-bound in our sort of accounting of the 14th Amendment. I mean, it seems to me that that's not really a very meaningful way of approaching language if we're trying to understand, like, why this language is even there. So I guess if you'd like to interpret, my comments about the citizenship guarantee and the equality principle, think of it as just as a marker for a value. It's a value statement in the 14th Amendment, which, if you want to import it into your construction of the Equal Protection Clause or directly the Citizenship Clause or frankly the Due Process or the other clauses, all of that seems fine. It's just that there's a value that's been missing in order to supply, what Owen Fisk, calls a mediating principle for interpreting this very vague language. You need some mediating principles that make, general language actionable. And when you're selecting these mediating principles, why select one that departs so far from, some really rather immediate things that the text offers you? And that would make, in some sense, a more meaningful, at least in historical terms, more meaningful account of what the 14th Amendment is about. And so, I don't put much stock in the idea of clause switching or whatever. It's that you need to account for the values that are stated in the actual text of the Constitution.
More questions? Yes. Yes, you.
Hi, it's Jamal Green, Columbia Law School. I'm going to break decorum and just re-ask what Barry Friedman asked that I thought wasn't addressed, which was the possible downside of switching to a clause that focuses specifically on citizenship and as opposed to persons or people, and ask whether, I mean, if one of the benefits of switching to the Privileges and Immunities Clause is the clarity of the text, I can imagine some very pernicious results, even if there are ways of arguing either through original understanding or through other manipulations of the text that it shouldn't actually apply only to citizens. It seems the clearest reading of the clause suggests that it is limited in that way.
There were a couple, yes, yes.
Okay, I'd like to ask the proponents of making this switch to just say a little bit about how they would actually do it. Say that Chief Justice Roberts were here and was looking forward to his next 35 years as Chief Justice and was persuaded by Randy and Doug and Goodwin that this really would be an excellent signature for his reign. What would the strategy be? How would you develop it? What kinds of cases would you take on? How would you explain to the public why this was something that was just not some kind of very esoteric debate among lawyers as to which clause to deploy?
35 years of Roberts, a sobering answer to President-elect Obama. And how about Steve, and then we'll...
Steve Calabresi at Northwestern. Randy Barnett read from Corfield against Coryell, and he read at the end the passage where Justice Washington says that all of the rights that are protected are subject nevertheless to regulation through general laws enacted for the good of the whole people. And that is a big but in terms of the protection of rights that's being offered. I wondered if the panel had any thoughts about what the qualification subject nevertheless to general laws enacted for the good of the whole people means, and whether that doesn't just yield something like the rational basis test that the court talked about in Caroline Products.
Okay, and how about Neil, as is customary, the last question, and then we'll have quick answers from the four of you.
Okay, a thought about answering the question that Barry asked and that Jamal asked again. Doug, you mentioned Justice Ginsburg's language about equal citizenship stature. And if you look from her confirmation hearings, her statements on and off the bench, she frequently recurs to this theme, right, about expanding the constitutional conception of we the people, right, to include previously excluded groups. She also uses interchangeably full human stature and essential human dignity. Right, so she uses these three phrases repeatedly: equal citizenship stature, full human stature, essential human dignity. That doesn't mean that's going to be the authoritative interpretation of this of the Privileges and Immunities Clause because she said it, but at least it does admit the possibility, right, of a conception of citizenship that's not in the technical legal sense of immigration law, but rather a member of the political community.
All right, well, how about if we start with Goodwin this time and come back and then just a few minutes each.
I think that this point about citizens and persons is a very beguiling aspect of the 14th Amendment, and I'm sure I have a great answer for you. I've looked into it, quite a bit myself without feeling very satisfied at all. I suppose one could say that there are thick and thin conceptions of rights. That it is one sort of little insight you get from the text is that the reference to due process of law and the equal protection of the laws, the phrases that apply to persons, have a somewhat more procedural sound to them. Even equal protection of the laws sounds procedural in a certain way. And so there is a kind of floor of rationality / non-arbitrariness that must characterize law. And that is kind of the universal principle, it seems to me. So that's one reading of the reference to persons. I think it's what Neil suggests about membership in a community also strikes me as an important concept. The difficulty, I think, with the interchangeability that Justice Ginsburg has is that the text makes specific reference to citizenship in the United States. So it's not that, I mean, the Corfield quote refers to citizenship in a rather more general way, right? It's talking about the idea as using citizenship kind of in opposition to statelessness. So what it means to be part of an organized society is to have certain claims upon the society. That may be, what they're talking about here, because where else are you going to be a citizen except in the United States for purposes of the U.S. Constitution? But the notion that's being argued for here may be the one that is in Corfield and the one that I think Justice Ginsburg is trying to enunciate, which is the idea of what it means to be a member of an organized society. And thus that has perhaps a more expansive view that can cover, if you will, or elide, if you will, the distinction, make it less firm, this distinction between citizens as in who has the requisite paper versus those persons who may not have the paper. But those are just ruminations. I don't have a great answer on this question yet.
I think I want to respond maybe to the strategy question and at the same time reinforce some things that Goodwin has said, that before the amendments passed, John Bingham, who by all accounts is the author of Section 1, except citizenship clause, says over and over again, I mean, this goes back 10 years before it's passed, that the whole government's founded on equality. He doesn't view, he views the 14th Amendment and equal protection as giving additional protections and enforcement for that. But I mean, I think the framers start out with the idea that the whole Constitution, because of equal citizenship, because of the Ability Clause, all kinds of reasons, is founded on equality even before the 14th Amendment. And I think maybe, again, the answer on strategy may be, it's always difficult. You read a case when you are preparing for class, you see something differently than when you're not. You read a case when you're prepared, when you have a client you're representing, you see stuff you didn't know. So I don't have any client in this right now, so I don't know what I would see later, but when Goodwin was talking about looking at the whole clause, maybe a clue here is Justice Black. Justice Black, when he dissents in Adamson, I've read a couple things by some pretty prominent people lately that talk about blacks looking for a new due process clause in Adamson. He's not. If you go back, I mean, I thought, boy, did I misremember this? You go back and look, every place in Adamson, Black invokes Section 1. He doesn't invoke privileges and immunities. He doesn't invoke citizenship. He doesn't invoke due process. He's got a lot of that in the appendix. But I think if I were litigating this, I might, as a lawyer, maybe not as a judge, but as a lawyer, I would try to invoke the entire clause instead of relying upon any one part of it. And again, it keys into some of Rebecca's work about citizenship clause as well. And I want to just mention one other thing, and that is, I think there's serious and important concerns about tying this to citizenship because of what it would do to people who aren't recognized as U.S. citizens. But if we go back to Rawls' treatise on constitutional law, the first constitutional law treatise, he was the guy that Washington wanted to be Attorney General, and he refused because he didn't want to leave Philadelphia, so Washington made him a U.S. District Attorney there. He says when he's going through the Bill of Rights, and he gets down to, he's covered all the criminal procedure rights, for example, he says, and due process is just the summary of all of these prior rights. Now, maybe that doesn't get us First Amendment. Justice Curtis, whose biographer says he's probably had the greatest impact of the 19th century court in trying to figure out due process. And remember, the distinction between substantive and procedural due process doesn't exist until the 20th century. I mean, they're not talking about this, but Curtis also says basically that due process it kind of summarizes many of these other procedural issues. So it could change the status of aliens, but it's not, I think we need to work through that, but it's not nearly as dramatic as what people might expect.
This is in response to Stephen's question. One of the we obviously remember footnote 4 of Caroline Products about how specific prohibitions of the Constitution cause one to narrow the presumption of constitutionality. We forget there's another part of the text of Caroline Products. We forget this largely because it's cut out of modern American casebooks, in which the court says that it would be unconstitutional if a law were to preclude the introduction of proof that a statute was irrational as applied to a particular person. So there were two kinds of scrutiny that were approved by the New Deal courts, even though they created a two-tier. It was a tier where some rights were protected and then some rights were protected but not as much. And it wasn't until Williamson v. Lee Optical that as a practical matter, that road to scrutiny land was closed. So what I'm suggesting is that we have a conception of rights that survives the footnote 4 conception, this modern conception of rights as trumps, and that no statute can stand before them. They are that powerful. And if rights are going to be that powerful, you can recognize very few of them, because obviously the whole Constitution and all our systems of government presupposes there's governance. And if rights are so powerful that they defeat all statutes that might come before them, you have to have very, very few rights. And the problem is that there's a lot of other liberties that we have that are worthy of protection, that don't get put into the category of fundamental rights. And secondly, we don't actually protect these super-duper rights as powerfully as we purport to be doing, even in the areas that we claim them to be fundamental. So I think the answer to this question about Corfield is that all constitutional liberties may be regulated, including, for example, the constitutional right to keep and bear arms. But when these regulations happen, regulations in the sense of make regular, the government needs to have a legitimate justification for why it's doing so, and so the analysis should shift to what is their justification and what is a list of acceptable justifications and what are a list of unacceptable justifications, which is somewhat what Justice Kennedy was doing in Lawrence v. Texas. He was doing a bit of this shifting of methodology to looking at the justification, and we saw that in the city of Cleveland, of course, looking at what are tell us what the justifications are, and we'll figure out whether they're proper or not. So instead of putting all the emphasis on what are the privileges or immunities or the rights retained by the people, we say, look, liberties protected across the board, even liberties that we don't think are so fundamental, but by protected we mean when it applies to a particular person and they are told they can't do this, that, or the other thing, the government has to come in and justify what it's doing as necessary and proper under a reasonable meaning of that term, and we will then develop a jurisprudence of justifications. It's very similar, actually, from what I'm told, I really don't know this firsthand, to the structure of protection of liberty in Europe, in European legal systems. It's not the substance necessarily, but it's the structure that the burden is placed. People can go in and object on the grounds that their liberty has been restricted, and all the jurisprudence is on what the nature of the justifications are. Then they have a pretty capacious theory of justifications. But that's, in a sense, where I think the action should shift.
I'll just have two quick points. One is about the citizenship and who's in, who's not point. And the point I'd make is just a fairly realpolitik one, which is that you have the shift to due process from two privileges and immunities from due process arguably entails two groups being left out. One is resident aliens, the other are corporations. Resident aliens is going to make a lot of progressives on the court and outside the court very uncomfortable. Leaving out corporations is going to leave a lot of conservatives and on the court and off very uncomfortable. I suspect that somehow the court will find a way to include both under the Privileges or Immunities Clause. Now, that's not a textual point. I'm not saying that's the right answer. But there's this dynamic which is, I think, will push against going one way or the other on that. The second point is in response to size, which is more of a how you go about moving an agenda like this. And I think, and the reason why I talked a fair amount about the Heller on remand case is I think that it's going to be pretty critical to go step by step and not ask the court to do too much if you're asking them to do this. And I think raising this first and bringing this next to the Supreme Court in an incorporation context where, as we've all described, there's pretty remarkably unanimous agreement about the right answer to that question, what incorporates the Bill of Rights against the states, is at least the smallest step that you can ask of the Supreme Court as a first one. And then we actually, in terms of what the court would say, I actually have the audacity to, in the forward of our report, write what I modestly call the two-sentence opinion that would write all of constitutional law. And I'll just read it, which is, the court's incorporation and fundamental rights cases according constitutional protection to substantive liberties previously considered to be cases interpreting the 14th Amendment's due process clause should be treated as cases interpreting the 14th Amendment's privileges or immunities clause, a proper source of substantive constitutional rights and liberties. Portions of the slaughterhouse cases and subsequent cases that are inconsistent with this opinion are hereby overruled. Now, obviously, that would follow 50 pages of analysis of all this, I would assume. But I think that's what you do.
You get your clerks to do that.
Right, but that's the main message. That you just, and you're right, it's a clause shifting, but I think that shift would be enormously important.
I'm going to take the prerogative of the moderator and respond to Jamal's question, which has concerned me a lot because I've written about the concept of citizenship as a basis for rights. And I think there's two different ways of citizenship that you could imagine this. There's an inclusionary way that is clearly evident in Reconstruction, which is they wanted to make free black citizens, they wanted to include them in the polity, they wanted to give them rights. And then there's an exclusionary possibility, which would be they didn't want to protect people who weren't citizens, right? They wanted to exclude non-citizens. And so I've read through the debates very carefully looking for this, and I have found really no evidence of the exclusionary policy, with the exception of what we were talking about yesterday, ambiguity with regard to Native Americans, right, that are living on reservations. The words person, citizen are used interchangeably, and there's some language in the that I mentioned yesterday, Lyman Trumbull saying, yeah, sure, Chinese and Gypsies are going to be included, and that's, and if you don't like that, tell that to the Germans in Pennsylvania. So that's still, I'm still nervous about it, as you are, but I think that's a little helpful anyway. So let's thank the panel here.